looking forward to today's discussion. It's a question we get a fair bit, and I'm just going to call up my screen about why are certain clauses appearing, and typically there's an explanation for it, but we always like your feedback as well. So I'm going to share my screen, and we've picked a few for us to cover, but happy to cover some other ones that maybe you guys have noticed and want to ask about or whatever. So the first thing is, let's just talk about, I'm going to open up the single will, and I'm going to show you a few of the clauses that are going to appear based on what we're going to do with the planning. So the first thing that I want to show is dealing with, and I'll go down to it, is in the definition sections. So a couple of things. So one thing you might notice is a situation where a class is identified, okay? A class will only be identified if it's necessary to identify that class. Namely, they've been included as a beneficiary. So somewhere in this will, my parents are a beneficiary. And that's why it is going to include that definition. If I name them specifically, then it wouldn't identify my parents. It's only going to do it for a class gift. And here it sees that we made a class gift, but we had no members of that class who were identified in our family tree. And so that's why it's highlighting that. So sometimes we get questions of, oh, why is it including my siblings, but not my spouse's siblings? Well, that's why, because my siblings are a beneficiary. Maybe I named the spouse's siblings specifically. If so, I don't need a class definition. Okay, so that's what that's in there for. You'll also notice that if you ever index a gift, there's going to be an inclusion of an indexing definition. Okay. Those are just a couple of examples of definitions that appear based on need. I mean, there's a whole bunch of other ones, but those are the most common ones that we see. We pretty much always have by default a personal effects clause. I built this because I didn't think that we should ever have personal effects fall into the residue. Instead, deal with them specifically, because if there are assets, for example, personal effects that you want to get rid of, you want to just throw out, or you want to donate or something, if you have it fall into the residue, you can't, you risk the residuary beneficiary saying, well, hold on a second, you shouldn't have thrown that out. You could have sold it. It was in mint condition. It was a rare antique. It was whatever. And so we almost, I think by default, it's going to include a personal effects disposition clause. And it assumes that you're going to do something with the personal effects in each scenario, or at least in one scenario. So that's why it's going to include that. In this case, just in this example, we didn't include in any, we didn't include personal effects in any, to any particular beneficiary. A couple of other things. So we talked about the idea of parents. Well, here, that's why, because it was a gift to parents. That's why the definition had that. I want to talk about children and exclusion of certain children when you're excluding them, or when you're or when a forfeiture clause comes up. So I'm going to demonstrate that. So what eState is doing here, and I'll just minimize this. So right now, it sees that, and it's checking for children, by the way. It's seeing that the two children are both included, and they're both getting the same amount of the residue. Okay. That's why in this draft, there won't be, if I refresh this, there won't be a forfeiture clause, okay? Or an exclusion of children clause, okay? If instead, though, if I give Benjamin 2/3 of the estate and Sally 1/3 of the estate, eState sees that. And what it does is it at least gives a heads up by including a forfeiture clause in the draft, because it saw that the children are being treated differently. And when it sees that, it's going to automatically put in a forfeiture clause. So that's what happened here. And it highlighted it and that kind of thing, because it wanted you to know that we've included it and for you to consider. Okay. If, on the other hand, we remove Sally completely and it sees you have two kids, but you're only including one of them in the will, for example, and in this case, it's going to check to make sure they're completely excluded. So I'm hoping that in this I've done that. But what's going to happen here is it's going to put an deliberate exclusion of Sally in here and highlight that. Okay. So those are two examples of when these two clauses would appear. It's not checking, by the way, for siblings. It's not checking for other people being excluded. So we understand that, and maybe that's something we'll build in the future to check more data. But that's when that happens. So we have that. If I ever, something that somebody just raised with us that I forgot about actually, if we say that the testator is, let's figure out who's our testator, Jennifer Craig. Okay. If we say that the testator is, has vision issues, okay? When we generate the document, let's generate one with an affidavit of execution. You're going to see that the affidavit includes the blindness clause, okay? It's going to do that by default when it sees, and I'll just preview this again with the affidavit. It's going to see that the testator has vision issues, and maybe we need that clause in the affidavit that talks about blindness. So that's what's going on there. I'm thinking we should probably highlight that, and I will do that. But here's the clause that appears because they're blind. Okay. So that's what we've got there. The last thing that I wanted to show, and then I'll get to questions, and feel free to post them in chat, is the BUCA clause. And that's, when I say that, that's the beneficiaries under certain age clause. Internally, we call that the BUCA clause. And I'm just going to call up this person. And I want to explain what's going on here. So what eState does, I'm just going to call up the single will. What eState does when it's creating a beneficiaries under certain age class, first of all, it checks to see, do we need that clause? Okay. So if there were no beneficiaries or they were charities, for example, you wouldn't see the BUCA clause, the beneficiary under certain age, because it knows that there's no possibility that anybody could receive money while under the age set out. Okay. But in this case, we have a gift to a sibling. So we don't know, we don't really trust you or the client when they put in age information. And where there's a gift over, for example, to a sibling and then to their kids, what the beneficiary under certain age is going to do is it's going to automatically include a perpetuities clause. Okay. Every BUCA clause has a perpetuities clause that looks something like this. And what we need to do is we need to find somebody who's a beneficiary, or if there is no beneficiary, somebody to use as the life in being to calculate how long the perpetuities clause is going to run. So we need the last survivor of someone. Okay. So here's the rule. So if you look on paragraph H, you'll see in this case it said the last survivor of my mother's issue. Why did it pick my mother's issue? It saw you had no descendants, so it couldn't use your issue. And it saw that you had a sibling. And so when it sees that, it says, okay, I'm going to try to pick somebody who's closest to the testator for a life and being. So I'm going to pick the testator's mother's descendants, which would include siblings, nieces and nephews, great nieces and nephews, etc. So that's what it's doing. It's picking the last survivor of my mother's issue. Okay. If, for example, though, and we get this question from time to time, I'm just going to get rid of the sibling here. Oops. Let's get rid of the gift to the sibling. Wait 1 second. So I think somewhere in here we have a gift to the sibling. Yes, remove. And let's get rid of the sibling. So let's take a person here who has no family members. They're, you're dealing with somebody who has no descendants, no siblings, etc. And we've got a gift to someone where there's a potential for a person inheriting money under the age of 25. What's going to happen here is it's going to use a life and being that was commonly used, which is Queen Elizabeth's life and being. So I'm just going to show you that. So here is the BUCA clause. We can't say the last survivor of my mother's issue. We don't know if you have siblings, etc., because they haven't been put in. And we know you don't have any descendants, or at least you haven't put in any. So we're assuming you don't have any. And so what it's going to do is pick the last survivor of the issue of Queen Elizabeth II. Now you might say, we got all kinds of questions after she died to say, oh no, you have to update this to be, King. I forget who the king's name is. Prince Charles. I guess Charles. Change it to his issue. We don't want a man as the life and being, like the issue to determiner, because men can have descendants that they don't know about. And so we typically, we pick the Queen of England. And we know, okay, who's the last survivor of her issue? Well, we know who her issue are, right? And so we can figure out from there. That's the typical thing. It doesn't matter that she's dead. We're still using Queen Elizabeth. It's easier than some other life and being, but you could pick any life and being that you wanted here. But by default, if we see that there's no relatives around, then we're going to use the Queen Elizabeth II and her issue. Okay. So we obviously want the longest period of time before the Perpetuities Act kicks in. So you can think there's a lot of issue of Queen Elizabeth II, and we can pretty much trace them. So that's why we do that. So that's what I've got to show you some automatic clauses that appear based on the data that eState sees in all of this. So that's what I want to talk about. Happy to. Are cars included under personal effects? Yes. So by definition, of course, you can change the definitions, but in our standard definition, it includes vehicles. Again, you could change that definition if you like. Any other questions? When do you use the replacement of trustees clause? So whenever it sees, really it's by default, we include it. We can, of course, we can go down here to the trustee replacement clause and exclude it if we like. Right now we include it. Or you can create your own custom one. So that's up to you whether you want to include it, etc. And when do we use it? It's usually when there's a trust involved, because it's not really for executors, it's really for trusts. And so when there is a trust, that's when I would probably include it, to allow the final trustee to appoint a replacement. Tim, let's talk about that offline, about how to name a monitor. We don't really support that, but there is a custom power of attorney provision that you could add in and save, and it'll always be there. So maybe we'll just chat about that offline. It depends, I guess, if the niece is over, we don't really check the age of the niece to see if she might be under the age, because we don't really trust when people put in an age. But you wouldn't need it in that case if the niece is over the age that you would want her to inherit with no strings. So that if you want, you can manually delete the BUCA. One of the things we always balance doing things automatically with the fact that sometimes the data that goes in is not that accurate, and we'd rather include a clause that might be unnecessary than delete a clause that might be necessary. So it's always a tension there, but that's, in that case, I would just delete the BUCA, assuming there's no gift over, as you said. Other questions? Just so everybody knows, we're updating, if anybody's appointing BMO Trust, we're updating the BMO powers. They've just been updated, so those will be updated by the end of the week, and so they'll automatically populate. Just a heads up, if you're doing one, you may find that the powers are not, they may reject it. So, but again, it's going to be it'll be this week. We're just finalizing the testing on that. What else is coming down the pike? We have big projects we're working on, so there's not anything small that we're releasing quite yet. But we're working on the questionnaire to make it more user friendly and B, customizable. So that's a big one. And also we continually work on the customization of documents and that kind of stuff. So working on those. And some infrastructure stuff for making everything more faster to use and things like that for document generation. I have a few minutes, so any questions about doing something? Anybody have any questions about something they're trying to do in eState? You feel free to unmute and fire away. Okay, good question. So customizing the documents. I'll just go. So you can do it in two places. Let's say you just want to customize it for a particular client. When you're working on the client, you can go in here and customize it, and it will be saved with that client. So for example, this very client, I do not want to include, the definition of unwilling to act. Okay, I just don't want to do it, or I want a custom one. Then I can deal with that. Okay, I can exclude that for this particular client. Okay, and it won't appear. I don't want the children born out of wedlock for this client. I can exclude it, won't appear. Okay, and it's saved. That's the big thing that we did, that we released last week, I think it was, is now when I go and I come back, that data is saved. So I open this up, it won't print those definitions. Okay, that's the benefit of this. Okay, same for the admin provisions, right? You can change, etc. So that's on the per client basis. Okay, so, and just to show you that, like down here, it would have deleted those provisions, right? So it no longer has that unable to act definition. So now, though, I want to leave this client and I want to go to my documents. And so this is how you customize your documents. Okay, so let's pick the short will. Okay, now I'm assuming if you're on a professional plan, you have the choice to choose to customize it only for myself or for the firm. If I'm an administrator, let's change it for the firm. Let's say you're on the growing plan, you'll be able to just change it for the firm. So I would go in here, and this is going to get saved and be my default every time I open up the short will. So I can choose, do I want designations included in my short will by default? Again, don't forget I can change it per client, but this is setting up your default. Do I want to by default include affidavits of execution? No. Let's set up my revocation clause. I want my revocation clause to read not the simplified, not that one. I want a custom clause. Sure. copy your custom clause from your own precedent, paste it in here, and it'll always be available. This is my custom revocation clause. Okay, period. So now when I open up the short will on any client, by default, that will come up, okay? Or I can choose it. So I can do whatever I like there. Same for your definitions. By default, which do I want to include, which I don't, etc. Remember though, that some of these are dynamic. Like indexing is not going to appear unless you have indexed a gift. So you don't have to exclude it because it's only going to get included if necessary. Okay, so that's just something to remember. And then on the admin provisions, obviously you can do the same thing. Which do we want? All of those, include, exclude, so you can customize that. Then we have other customization options, of course, that you've seen before, the name options, etc., the footer options, and then the formatting. What font you want, what margins you use, how you want the alignment, what decimals you want, or what number you want. So that would set it up as default. And then every time you open up the short will, it would go to that first. And then if you wanted to change it for a particular client, you can always do that and it would be saved for that client. Does that answer the question? Or is there some other formatting that you're thinking of? And as I said, we're building this template editor where you're going to be able to basically kind of change things around even more, move paragraphs around, build your own language that's dynamic, things like that. So that's coming down the pike. It's a huge undertaking, but we're working on it. Yes. Anything else? Just a plug for this Thursday. This Thursday, we've got a webinar on estate accounting, how to do estate accounting, some basics of estate accounting, overview of that, and then how we've invited Estateably, who's software that I use for estate accounting, how their new system works, and to make it efficient and those kinds of things. So it's quite revolutionary in that you can upload documents and it can scan it and things like that. So hope that that you'll come and learn about that. And the week after is Ian and Susanna. The week after that, we have a law pro coming to speak to the group, Ray Leclerc. So he's works for Law Pro and speaks often about liability and reducing liability for practitioners. So that's what we've got. So if there are no further questions, feel free to reach out anytime, of course, and we'll wish you a good afternoon and see you hopefully on Thursday. Thanks, everybody.